Kenyans in the diaspora who only vote for the president but did not take part in other elective positions. The differential also includes rejected ballot papers and stray votes which do not count as valid votes. The well-established principle that the person who asserts a fact must prove it casts the burden upon the first petitioner to demonstrate that there were instances of ballot stuffing of such a magnitude as to justify the nullification of the presidential election. Ballot stuffing, which is an illegal addition of extra ballots, is a type of electoral fraud aimed at swinging the results of an election towards a particular direction. Not a single document has been presented by the first petitioner to prove systemic ballot stuffing. A figure of 33,208 votes relied on in this claim is based on unproven hypothesis that since the number of votes cast for the president is higher than those for other positions, then without more, it must follow that there was fraud. We find that fraud is a serious criminal offense and it must be proved beyond reasonable doubt under Section 5N of the Election Offences Act. It is indeed an offense for a person to vote more than once in any election. IEBC has provided a plausible explanation for the vote differential, citing categories of voters who only vote for the president, such as prisoners and Kenyans in the diaspora. There were an insignificant number of stray votes whose combined effect cannot justify nullification of the election. Finally, on this point, a general election in Kenya comprises of 6 different separate elections held concurrently on the same day. Such elections are held by secret ballots, and one cannot predetermine the voter turnout or how voters will vote in each election. None of the parties has flagged anything so significant that it would have affected the outcome of the presidential election vis-a-vis the other 5 elections held on the same day. We find, therefore, there were no unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions. On issue number 6, whether IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138, 3C, and 138.10 of the Constitution. This issue arises from the printings in all the petitions as consolidated. Based on the said printings, the affidavits sworn in support thereof, and the written and oral submissions by parties, two viewpoints regarding the meaning, scope, and application of Article 138, 3C, and 10 of the Constitution have been advanced. On the one hand, the petitioners submit that pursuant to the foregoing provisions, the role of verifying and tallying of votes as received from polling stations countrywide is vested in the Commission as a corporate entity and not the chairperson of the Commission. It is their argument that the chairperson cannot undertake this task to the exclusion of other commissioners. They submit that the language of Article 138(3)(c) does not envisage a situation where the chairperson can arrogate to himself unfettered authority to verify and tally the results at the National Tallying Center without involving the other commissioners. Such action, they contend, would not only be unconstitutional, but would be sufficient ground without more to nullify an election of a president-elect. In support of their argument, the petitioners cite the Court of Appeal decision in INBC versus Mainakiai and 5 others as affirmed by this court in the case of Raila 2017. The petitioners further submit that Regulation 87.3 of the Election General Regulations is unconstitutional to the extent that it purports to vest the power of verification and tallying in the chairperson of INBC. On the other hand, the first, second, and third respondents submit that power to verify, tally, and declare results of a presidential election at the National Tallying Center is the exclusive preserve of the chairperson of INBC. According to them, there is nothing unconstitutional about Regulation 87.3 of the Elections General Regulations. The said regulation the respondents submit makes no mention of commissioners other than the chairperson. At any rate, the respondents argue Article 138(3)(c) of the Constitution does not envisage a situation where it is the commissioners who personally undertake the task of verifying and tallying the results as entered into the thousands of Forms 34A. Such an undertaking would be humanly impossible, they submit. For good measure, the respondents submit that Section 11A of the INBC Act provides that the chairperson and members of the commission are responsible for the formulation of policy and strategy of the commission and oversight. In their view, the Act does not contemplate a situation where commissioners would be directly involved in the verification and tabulation of presidential election results. The task of verification and tallying, as stated by the respondent, is executed by the staff of the commission under the direction and supervision of the commission secretary, who in turn reports to the chairperson. As to whether the chairperson acted unilaterally in verifying and tallying the presidential election results at the National Tallying Center, the petitioners claim that he did. This is what happened. It is the petitioner's case that the chairperson, 56 of 2022, in which he designated himself as the presidential returning officer, a position unknown in law and the Constitution. Having done so, the petitioner states that the chairperson proceeded to conduct the verification and tallying process to the exclusion of other commissioners, each of whom he had assigned verifiable roles and related to the verification and tallying exercise. The chairperson of IPC is submitted before eventually declaring the final matters any better by maintaining a stoic silence, even as things appeared to be falling apart. All this, in our view, points to a serious malaise in the governance of an institution entrusted with one of the monumental tasks that obviously needs far-reaching reforms, of which we shall say more in our detailed reasons. But are we to nullify an election on the basis of a last-minute boardroom rapture, the details of which remain scanty and contradictory between the chairperson of the commission and some of its members? In the absence of any evidence of violation of the Constitution and our electoral laws, how can we upset an election in which the people are participating without hindrance? As they made their political choices pursuant to Article 38 of the of IMC. This we cannot do. Clearly, the current dysfunctionality at the Commission impugns the state of its corporate governance, but does not affect the conduct of the 2022 election. In view of the foregoing, we are satisfied that notwithstanding the divisions apparent between the chairperson and the 4 commissioners, IMBC carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 10 of the Constitution. Issue number 7, whether the declared President-elect attained 50+1 of all the votes cast in accordance with Article 138 of the Constitution. The first, second, and third petitioners averred that the first respondent did not garner 50%+1 of the total votes cast, and therefore did not meet the threshold provided by Article 138(4)(a) of the Constitution. They anchored their claims on the basis that in order to determine whether a candidate has attained 50%+1 of the votes cast, this ought to be calculated based on the total number of votes cast, excluding rejected votes. They argued that 50% of 14,351, which amounted to 7,176,582.77 votes. They therefore contended that by attaining 7.176141 votes, the first respondent did not meet the constitutional threshold to be declared president-elect. Supporting the claim that the first respondent did not meet the 50+1 constitutional threshold was the sixth petitioner. His contention was founded on the backdrop of a press briefing issued by the chairperson of IMBC after the official closure of voting on 9th August 2022. According to the sixth petitioner, the chairperson of IMBC announced that the voter turnout was 65.4% of the total number of registered votes based on the verification of the KIMS kits which were functional during the process of voting. In addition, the sixth petitioner urged that the voter turnout of 65.4% did not include some 238 polling stations where the KIMS kits and malfunctioned, necessitating use of the manual register. It was therefore urged that the minimum number of votes cast could not be less than 14,466,779. Additionally, that this number was bound to increase once the number of votes from the areas that used the manual register were included. The sixth petitioner further claimed that a summation of the minimum number of votes cast and untallied manual votes would represent the actual voter turnout. In challenging the declaration made by the chairperson of IEBC, the sixth petitioner affirmed that the final tally, published in Form 34C, only accounted for 14,326,641 votes cast, including some 113,614 rejected ballots. The sixth petitioner contended that this tally did not factor in some 140,138 votes cast using the manual register. The sixth petitioner computed this number by subtracting 14,326,641 declared votes cast from 14,466,779 generated by the sixth petitioner as representing 65.4% of the voter turnout. Referring to the tallies in Form 34C, the sixth petitioner summed the number of votes cast for each candidate as follows: Raila Odinga, 6,942,193; William Ruto, 7,176,141; Wahiga Mwaura, 31,969, adding to a total of 14,213,027. He then added 138,000 arranged to be unturned votes, and this yielded a total of 14,353,165 total valid votes, which the sixth petitioner used to compute the percentages garnered by each candidate as follows. William Ruto, according to him, garnered 49.9%, Raila Odinga 48.3%, Wahiga 0.22%, and Wanjakoya 0.3%. It is on this basis that the sixth petitioner grounded the claim that none of the candidates met the constitutional threshold as set out in Article 138(4)(a). IEBC and its chairperson disputed the sixth petitioner's claim. They submitted that the declaration of results is based on the number of people identified as having voted on the KIMS kit and not the total persons on the voters register as arranged. They contended that those who voted manually was 64.76% and not 65.4% as arranged by the petitioners. They urged that the announcement error by the chairperson of IEBC on 10th August 2022 was immediately clarified during the same press briefing, and evidence of this correction was provided to this court in an affidavit of the first and second respondents in Presidential Election Petition number 7 of 2022. According to IEBC and the chairperson, 14,239,862 voters were identified using the KIMS kit, while 86,889 voters were identified using the printed voter register. Therefore, the total valid votes cast were 14,213,137, while the total number of rejected ballots were 113,614. 614, constituting 14,326,751 total votes cast. They illustrated that the first respondent garnered 7.176141 votes against 14,213,137 total valid votes cast, yielding a percentage of 50% Raila Odinga 48.84%, William Ruto 50.48%, Waiga Mwaure 0.22%, and George Wanjakoya 0.43%. IEBC and its chairperson also submitted that the KIMS kits malfunctioned in 235 polling stations, necessitating the use of the printed voter register. In these polling stations, backup KIMS kits were respondent in response to the question of 50+1 constitutional threshold, maintained that he attained the threshold under Article 138(4) of the Constitution as elaborated by the IEBC and the chairperson. This court has considered the differing formulas and threshold arguments presented by various parties to this petition, while the first, second, and third petitioners raised pertinent questions connected to this issue. We shall address them together with those of the sixth petitioner, who has addressed and focused on the issue as specifically framed in detail. It must be restated that the data-specific threshold as enunciated under Article 138(4) of the Constitution, that without attainment of which there can be no declaration. This data is on almost other petitions numbers 2 of 2017, consolidated, referred to as the ultimate yardstick for determining the winner in a presidential context. In Raila Odinga and 5 others versus IEBC petition number 5, 3, and 4 of 2013, this court asserted that rejected ballot papers do not constitute a vote cast to be included in calculating the final tally in favor of a presidential candidate. We are not persuaded by amicus curiae's brief, that is Law Society, who attempted to persuade us to consider our position on this finding. We reiterate that rejected votes cannot be taken into account when calculating whether a presidential candidate attained 50% in accordance with the Article 138(4) of the Constitution. Similarly, same right laid down the pattern of burden that the proof required in dispute challenging the outcome of a presidential election. And this is what the court said, and I quote, in the case of data-specific electoral requirements such as 4 of the Constitution, for an outright win in the presidential election, the party bearing the legal burden of proof must discharge it beyond any reasonable doubt. The question that follows was whether the petitioners challenging the attainment of 50% plus 1 constitutional threshold and the computation by the 6th petitioner in general. Computation was a press briefing made by the chairperson of IBC on 10th August 2022, when the evidential burden shifted to IBC and its chairperson, as it does in election cases. They produced video evidence correcting the percentage voter turnout to read 64.6 at the time of the briefing. This percentage, however, did not include reports from all the KIMS kits and 86 that were identified using printed register of voters. In our view, the assertion by the 6th petitioner that the percentage voter turnout was firstly predicated on the correct the chairperson petitioner based his percentage of voter turnout on the total number of registered voters, while the chairperson of IBC made reference in the press briefing to the number of registered voters who were identified through the KIMS kits progressively. The 6th petitioner also asserted that rounding off of votes cast in a presidential election as a means of assessing the threshold under Article 138(4) of the Constitution kills and bars voters, which is illegal and unconstitutional. We have deliberated on this proposition and found that it is not mathematically sound and that the rounding off done by IBC and the chairperson was correct. Consequently, we find that the petitioners did not provide a watertight case to warrant the setting aside of the results of the presidential election on the basis of not having met the threshold provided under Article 138(4)(a) of the Constitution. On the voter turnout, therefore, we find that the formula predicated on the number of voters identified through KIMS kits progressively and used by IBC and the chairperson to generate a percentage of 64.76% was correct. Having settled the issue of voter turnout, we must ask ourselves whether in the making of the declaration, the chairperson of IBC applied the formula in Article 138(4) of the Constitution, which is total gives IBC and so rate to 14,213,137 divided by 2 plus 1, which makes 7.106569. The question that must inevitably follow is whether this formula, when applied, will confirm that 7,106,569 votes is less than 7.176,141, which represents the number of votes received by the first respondent. We find that it is, as such, on the basis of the foregoing formula and from the numbers provided by IBC and its chairperson and the declaration by the chairperson of the President-elect on 15th August 2022, it is our finding that the declared President-elect attained 50% plus one of all the votes cast in accordance with Article 184 of the Constitution. Issue number 8, on whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. Although the petitioners have provided numerous averments pointing to possible irregularities and illegalities marked by failure of technology, arranged voter suppression, printing and utilization of Book 2 of 2, EU preparation by the INBC and its chairperson, commission indiscretions, transposition anomalies, agent absence, and many others, we are of the view that the pointed illegalities and irregularities were not of such magnitude as to affect the final result of the presidential election. We will delve deeper into the details of this issue in our recent judgments. Last issue, what reliefs and orders can the court grant? Under Article 163(3) of the Constitution, it is provided that the Supreme Court will have A, exclusive original jurisdiction to hear and determine disputes relating to the election of the office of the President arising under Article 140. And Article 140 provides, I quote, a person may file a petition in the Supreme Court to challenge the election of the President-elect within 7 days after the date of the declaration of the results of the presidential election. 2, within 14 days after the filing of a petition under Clause 1, the Supreme Court shall hear and determine the petition, and its decision shall be final. If the Supreme Court determines the election of the President-elect to be invalid, a fresh the mandate to determine the validity or otherwise of the election of the President-elect. It is clear to us that the jurisdiction of the court is quite circumscribed in terms of the orders, petition under Article 140 of the Constitution. In the event the court determines that the election of the President-elect is invalid, it must make an order nullifying the election. Consequently, it has also to make an order directing INBC to hold a fresh election within 60 days after the determination. Should the court determine and Articles 160 and 140 stops the court from issuing orders or reliefs by way of recommendations. Indeed, since 2013, this court has issued many recommendations arising from the determination of 3 petitions challenging the election of the President-elect. The recommendations are meant to improve our electoral landscape, and this court has been greatly aided by the contributions also of the amici curie. And the court places a heavy premium on those briefs that were filed and those which were admitted. The final is a unanimous decision of the court, and we make the following orders. 1, the presidential election petition number E005 of 2022 as consolidated with the presidential election petition numbers E001, 2, 3, 4, 7, and 8 of 2022 are hereby dismissed. As a consequence, we declare the election of the first respondent as president-elect to be valid under Article 143 of the Constitution. This being a matter cutting across the public interest, we order that each party do bear their own costs. It is so ordered. And finally, the court has asked me to also acknowledge, although we'll do it in the long draft, the enormous contribution made by council in these proceedings, and also the orderly way the council, all the advocates and parties conducted themselves. They remained seated throughout the proceedings. That is the judgment of the court, a unanimous one. We shall issue a media summary to help the media summarize the case.
Madam Chief Justice and the learned judges of this court, again, I am requested by my colleagues. Thank you for deliver judgment to us, giving one judgment move forward. Thank you. And
let me, on behalf of the lawyers for the counsel for the first and second petitioner, thank the court, and it has been a journey, worthwhile journey, sitting through these proceedings within the time stipulated. We thank you.
Madam President, members of the court, I wish to request just a couple of minutes for the chairperson of the Law Society of Kenya to make a few remarks in appreciation of exercise, if you allow. Thank you. I call upon Mr. Eric Theuri to come and make his remarks. It is also his birthday. I would have sung happy birthday.
the deputy Chief Justice and all the justices of the Supreme Court. I think before the
this is very important because for pilots to